Thank you for attending today's Researcher Talk. I'm Richard McCulley. I'm the historian at the Center for Legislative Archives that sponsors this series. We like to hold about one Researcher Talk each month. May is a very busy month with many of our scholars who've researched Senate and House records on the move. So we've got a double header this month. In addition to today's, next Thursday, we have another Researcher Talk and host Magdalena Krajewska, Assistant Professor of Political Science at Wingate University, whose talk is titled The Politics and History of National Identification Documents in the United States, 1915 to 2015, Lessons from the Archives. Today's speaker is George Yin, Edwin S. Cohen Distinguished Professor of Law and Taxation at the University of Virginia School of Law, where he has been on the faculty since 1994. Professor Yin has extensive experience on the Hill. He was the Chief of Staff of the Joint Committee on Taxation from 2003 to 2005, one of the most influential tax positions in the country. In that capacity, he assisted Congress on a number of important bills, including the Jobs and Growth Tax Relief Reconciliation Act of 2003, the Working Families Tax Relief Act of 2004, and the American Jobs Creation Act of 2004. Prior to service on the Joint Committee, George served as tax counsel for the Senate Finance Committee and coordinated a major project to reform and simplify the tax laws relating to corporate mergers, acquisitions, and reorganizations. He has served as a consultant to the American Law Institute, the Department of Treasury, the National Commission on Restructuring the Internal Revenue Service, and the Select Revenue Measure Subcommittee of the House Committee on Ways and Means. He is currently a member of the IRS Advisory Council. He is co-author of case books on corporate and partnership tax and has written widely on tax policy issues and the legislative process. On top of all this, he has devoted considerable time to researching the records of the Joint Committee on Taxation and is joining us today for a talk titled The Early Years of the U.S. Joint Committee on Taxation and Some Current Implications. We should have time for Q&A, and if you have a question, please raise your hand so we can pass the microphone. Thank you, George, for joining us today.
Thank you very much, Richard, and thank you all for coming. Let me introduce one guest here that you don't know. Ron Perlman came in. Ron is actually a former Chief of Staff of the Joint Committee himself, and even before that he was the Assistant Secretary for Tax Policy at the Department of Treasury. He's also been on the law faculty at Georgetown University. So thank you for coming, and let me begin my talk by just simply thanking you for the work that you do, for those of you who work in the archives or work in historians' offices and so forth. I've felt that I'm in a very privileged situation to have served as Chief of Staff of a committee in Congress, and now having the time and the interest to actually try to do a little in-depth research about the history of the committee and the staff. And as you might guess, many of my questions are ones that occurred to me while I was serving in Congress, but simply had no time to investigate them. I obviously could not be doing much of my research but for the care that you and your predecessors have done to preserve so many of these important historical documents that obviously preceded my service. So thank you all for the work that you do on behalf of myself as well as obviously the many users of your services. In today's talk, I'm going to just talk briefly about what the Joint Committee is, and then I'm going to talk about 3 research areas where archival documents that I have found either here or in your College Park location or at the Library of Congress have proven to be very helpful to me in my work. The 3 areas I'm going to touch on is first the history of the Joint Committee on Taxation, second two specific parts of that history that I examined closely, and then finally some of my ongoing work with possible current implications. As Richard indicated, please feel free to raise questions as I go along. That will be just fine. So the Joint Committee on Taxation is a committee in Congress, and it consists of 10 members, 5 from each of the 2 tax writing committees, the House Ways and Means Committee and the Senate Finance Committee. In each case, it's 3 members from the majority party at the time and 2 members from the minority. By tradition, the most senior members of the tax writing committees become members of the Joint Committee on Taxation. And also by tradition, the chair alternates between the first session, where the House Ways and Means Committee chairman is the chair of the Joint Committee, and the second session, where the Finance Committee chair is the chairman of the Joint Committee. Now, the activities of the committee are essentially nil. So when I joined the staff, as Richard mentioned, at the very beginning of 2003, it was the first or second week of February of 2003, there actually was a meeting of the Joint Committee, and they convened it for the purpose of welcoming me to the staff. I did not realize at the time that for that year, 2003, that would be the only time the committee would meet. And indeed, it is very common practice, certainly the years I was there as well as other years, where the committee may meet only once during any given year, usually a relatively pro forma organizational meeting for the sole principal purpose of electing the chairman, which, as I said, by tradition is pretty much determined in advance. In addition to rarely meeting, the committee rarely holds hearings, which is obviously an important legislative function. And most importantly, the committee does not report out proposed legislation, which is probably the most critical function of most committees. Nevertheless, the committee does have a staff. The staff in recent years consists of about 50 to 70 people. Most of them are lawyers or economists. There are a few accountants, information technology people, support staff that make up the balance. Many of these people are career staff. Most of them are very highly educated and experienced in their fields. The staff is a nonpartisan staff, to be distinguished from a bipartisan staff. So you don't have, as is true in many committees today, a situation where you have certain Democratic or Republican staff that are dedicated to working with the members of their party on that committee. But rather at the Joint Committee, essentially all of the staff works with all of the members without regard to partisan affiliation. The committee is headed by a chief of staff who oversees the entire staff. The typical chief of staff is somebody who pretty much came up within the ranks, moved up into a senior position on the staff, and then at some point was selected as the chief. I would say in the last 30, 35 years, it's not uncommon for the person who served as chief of staff upon leaving Congress to go into the private sector, one of the organizations in the District of Columbia, sometimes even in a lobbying type position. My selection was a little bit unusual in that although I did have experience working on the Hill, I had never worked on the Joint Committee when I was selected. And after I left, my intention was to simply return to my position at the University of Virginia, which is what I did. So I hope you have a question in your mind at this point, which is, how do we square the absence of any committee activities with the presence of this large staff? What exactly then does the staff do? So the answer to that is actually relatively straightforward. The Joint Committee members, as I indicated, consist of the senior members of the 2 tax writing committees. So if the Joint Committee were to undertake any legislative type activity, such as hearings, reporting out legislation, For the most part, what the Joint Committee would be doing would be taking away jurisdiction that is otherwise held by the two tax writing committees themselves. Now, since there's overlap in membership, you might say, well, big deal, but it actually is a big deal because, of course, the junior members of the two tax writing committees are not on the Joint Committee, so they would be the losers if that were to take place. And as a result of that, by tradition, the Joint Committee simply refrains from doing those traditional legislative activities, leaving it to the tax committees themselves to hold the hearings and to propose legislation and the like. On the other hand, the Joint Committee staff does provide technical and policy support on virtually all of the tax issues that all of the members of the tax writing committees consider, and indeed all of the members of Congress, whether they're on the committee, the tax writing committee or not. So, for example, the principal staff duties include supporting all aspects of the legislative process, much the way committee staff in general does in different areas. The staff helps to develop and evaluate various proposals. It receives input from the public on those proposals. It helps put the proposals into legislative language. It analyzes the effects of the proposals, the legal, economic, and revenue effects. Discusses the pros and cons, testifies before the tax committees, including at various markups, drafts the committee report, and essentially does all of the steps necessary other than voting that would go into the enactment of a particular proposal into the law. The staff also performs oversight over the IRS, and one specific duty which it has is to review all refunds that the IRS makes in excess of $2 million for individuals and $5 million for corporations. The staff also conducts investigations. Probably the most famous investigation is the one that it undertook in the early 70s, involving some of the tax positions that former President Nixon had taken. A more recent investigation was one involving the tax positions of the Enron Corporation. The staff prepares various studies on specific tax topics as well as simplification and tax reform proposals. And finally, the staff has access to otherwise confidential tax return information. This access is used both to help identify and anticipate problems that are in the law, as well as to estimate the revenue effects of various proposals. So in summary, in several respects, the Joint Committee is really unlike any other committee in Congress. It doesn't perform the traditional duties of a committee. It has a staff, but it has a nonpartisan staff. It has a joint staff, which is also unusual. The staff is exclusively devoted to just one area, tax. Obviously, there are other offices in Congress that have some similarities to this, and I'm thinking of the CBO, the CRS, and the GAO. I think one distinguishing feature that really makes the Joint Committee unique is the Joint Committee is performing these traditional committee staff functions, working day to day with the members in the actual, the gears of the legislative process, as opposed to simply providing input, which is used in the process, but not actually working in the actual process itself. That, as far as I see, is a unique aspect of the Joint Committee.
Is there a separate staff for the Ways and Means and the Finance Committee, and how do those staffs interact with the staff of the Joint Committee?
So Rod, that's a great question. The answer is that for roughly the first 50 years of the Joint Committee's existence, the other tax writing committees, for the most part, didn't have any professional assistants helping them, and so the Joint Committee more or less had a monopoly in the legislature to provide that kind of tax expertise, beginning sometime around the mid-1970s, and it's kind of modified over the years, but that statement is no longer true, and that in today's world, both the Finance Committee and the Ways and Means Committee have professional staff helping both the majority and the minority separately, in addition to the Joint Committee staff. And so that actually is one of the dramatic changes. I'll touch on this at the very end, because I do think that's kind of an interesting evolution, which has some kind of current implications, if you will. So, okay, well, at this point, I hope you may have, and certainly I had, this idea of, well, where did this structure come from? Why did they set this up the way they did? And so that was kind of the thrust of most of my early research. The Joint Committee was authorized in 1926, 90 years ago, and it involved a blending of interests on the part of the House and the Senate. So let me just sketch them out for you very quickly. On the House side, the interest principally developed as a result of what happened to the modern income tax, the tax that was enacted in 1913 following the ratification of the 16th Amendment. The original tax, the 1913 tax, was really a very small and fairly straightforward tax. It was kind of a trial run, if you will, on the part of members who really had almost no experience with an income tax. So this was kind of a trial run. And the way they made it a trial run is they created a very high exemption amount below which somebody, the amount of income below which somebody would not have any obligation under it. And so roughly 98% of the population was exempt from the tax. So for them, the tax didn't exist. The only about the highest 2% by income of the population was subject to the tax, and most of those people had to pay tax simply on all of their income at a 1% flat rate. So even for them, although they are subject to this tax, obviously it was a relatively de minimis tax that was being imposed. Just to give you an example, they did have tax rates that went up to 7%. That was the top rate in the 1913 tax. Only about 20,000 households had to pay the top rate. And just to give you an idea, put that in that number in some perspective, in today's world, the population of the country is a little over 3 times what it was in 1913. In 1913, it was about 100 million, and right now it's about 320 million. In today's world, we have a little over 500,000 people who report adjusted gross incomes of $1 million or more. And so if you kind of do the numbers quickly in your head, you realize that 20,000 people in 1913 world was really the very tiny, thinnest level of the population, the highest of the high in terms of income. Those people were subject potentially to a tax rate of 7% or up to 7%. Most then are either taxed at 1% or the vast majority not taxed at all. Corporations were also taxed. Their income was all taxed at a flat rate of 1% also. Okay? So you get a picture of, again, a very trial run. And of course, this was all intentional because, frankly, the people who were putting the tax together understood. They didn't really understand all of the details and the institutional needs. Let's just kind of give it a try and see how it works. Now, all of that suddenly changes as a result of the Great War. So the Great War starts, and suddenly it has 2 very important changes on the fiscal needs of the country. One is obviously increases the revenue needs of the country, but the other is it tends to dry up the major source of revenue that the country had relied upon, which was tariffs. And so for both of those reasons, Congress, at the urging of the Treasury Department, suddenly turned to this new trial run income tax and said, gee, we need this to really generate some revenue for the country. And so Congress passed a major act in 1916, 2 major acts in 1917, and another very major act in 1918, all making dramatic changes to the income tax as well as adding other taxes, including the estate tax. Just to give you one number, between fiscal 1914 and fiscal 1918, there was a 4,000% increase in the amount of revenue generated by the income tax between those 2 dates, just 4 years apart. Now, the 1918 tax was not yet what we think of as a mass tax. That is, it still largely impacted only people at the top of the income level. It was much broader than the 1913 tax, but it was still affecting about 10 to 15% of the population. So the vast majority of people still are exempt, even under the 1918 tax. But you have a greater number who are taxed, and those who are taxed suddenly face a tax rate potentially, or top tax rate, of not 7%, but 77%. So you can kind of see the stakes suddenly become much more important to those people who are subject to the tax. The corporate tax rate, likewise, was dramatically increased from 1% to 12%. And then in addition to that, Congress added something known as an excess profits tax. And what that did, as its name suggests, is it tried to tax businesses on the excess amount of their profits in excess of whatever would be considered kind of a normal or ordinary level of profits. And this excess amount was taxed at rates of up to 80%. So you can kind of see the picture of this income tax system writ large dramatically, almost overnight, turning around. Okay? Now, what happened as a result of that? Well, you can kind of pretty much figure it out yourselves. Essentially, nobody was prepared for these dramatic and swift changes. Congress certainly was not prepared. Congress was very busy doing a lot of other things, but it also was busy churning out this new legislation trying to meet the fiscal needs of the country. The new legislation introduced a whole host of complications that it couldn't quite figure out, or sometimes made efforts to figure out, sometimes not completely successfully. The high tax rates suddenly raised issues that were there all along, but simply, were not important enough to worry about in 1913. So if you think about fairness concerns, or you think about tax avoidance problems and so forth, not a problem for 1913, but boy, by 1918, those are big deals that you've got to start to address. The administrative agency, which was the Bureau of Internal Revenue, the predecessor to today's IRS, was equally unprepared. As one observer indicated, described it, almost overnight, it became necessary to establish the largest tax gathering organization the world has ever seen. And it all had to be done in the midst of the bewilderment of war, when obviously there were shortages of qualified people because of the needs of the armed services. Just as one example, the the Bureau of Internal Revenue, when they started in 1913, they started with this policy of auditing all tax returns, unlike today's world where obviously just a tiny sliver of returns get audited. And the reason for that was they expected few returns to begin with, and they also wanted to learn. The audit was a process to actually figure out, well, where are the problems, and so we understand how the law should evolve and so forth. In 1916, there were 300,000 returns to be audited. By 1922, there were 2.5 million unaudited returns that had created this huge backlog at the agency. Finally, taxpayers were equally bewildered by all of the changes. Some number of them obviously didn't understand what their new responsibilities were, and they couldn't get good guidance anywhere. The Bureau of Internal Revenue was, for the most part, too busy to put out good and useful guidance to explain how the law was supposed to work. And the private sector was very short on advisors. The demand for private advisors was so great that the Bureau of Internal Revenue during some of those years was experiencing a turnover of over 100% of their personnel each year. What would typically happen is you'd have some young bright person going into the Bureau, working there for 6 months, 9 months, maybe a year, getting trained and familiar with the law, and then the best of them would quickly move on into the private sector where they could get greater amounts of compensation. So all of this kind of laid the groundwork for the House's interest, which in 1925, what the House did is they focused on fixing the law. They had taken some steps up until then, focusing on fixing the administration of the law. But by 1925, the House realized that, gee, maybe the law itself really needs to be modified in some serious way. And what the House did in 1925 is it passed a proposal to create the Joint Commission on Taxation, which was to include members of Congress and the public. And the purpose of this commission was to develop and report simplification proposals to essentially improve the law. The House designated this commission to be a temporary commission, a 2-year commission to expire at the end of 1927. So that's the House proposal in this tax bill that's moving through the Congress. The Senate interest in 1926 was in part the same. That is, obviously the Senate saw these same problems that the House had just seen, but the Senate also had another important driver that got the Senate interested in eventually creating the Joint Committee on Taxation. And this additional driver involved a feud that had developed between two individuals, Andrew Melon and James Cullens. Now, Melon, of course, was one of the wealthiest people in the entire country, and during the time that these events occurred, he was in the midst of serving his 11 years as Secretary of the Treasury under 3 presidents. Cullens was reportedly the wealthiest person in Congress at the time, and he had made his money as the number 2 person to Henry Ford in the Ford Motor Company. When he left Ford, he sold his stock and went into public service. He first served briefly as mayor of Detroit, and eventually in 1922 he was appointed as senator from Michigan. Now, the feud between these two gentlemen played out in 3 overlapping conflicts or acts. The first act or conflict involved a policy disagreement between the two. Melon's interest from the very beginning, when he started as Treasury Secretary in 1921, his priority in the tax area was to reduce the wartime tax rates that had gone up to, as I said, the highest rate of 77%. And his reasoning was something very similar to what we think of as supply-side economics today. So he argued that high tax rates deters business initiative, and it also results in a misallocation of capital because taxpayers start to decide what they're going to invest in and where they're going to invest based on tax considerations rather than good economic reasons. And he felt that by reducing the rates, that would eliminate or reduce both of those two consequences. I think it's important to understand that Melon was not articulating this position merely as a disguised effort to help the rich, if you will. Because, for example, he advocated repeal of the tax exemption for interest on municipal bonds, which was a very popular and common investment on the part of the wealthy. To Melon, however, he looked at that and said, this is a classic example of the tax system biasing your investment choices by investing in this particular security rather than in something else. So Melon wanted to get rid of that tax exemption. His overall goal was to try to figure out what tax rates would maximize revenue but burden productive capital as little as possible. Cullens soon disagreed with this policy position, and the two of them began kind of a serious policy debate, which then evolved into a very personal and public exchange of letters, which would be published in the major newspapers. Each one would submit their letter, and it would be put on the front pages of the newspapers at that time. And as I said, it became increasingly vituperative. I will say that I think it's fair to say it never got as bad as the discourse that we see in the current debates, but it was quite angry and personal. I think it was surprisingly personal in the way it came out, and it was all out in the open. In one sense, this was all kind of a puzzle because, after all, these are two individuals that have a lot in common. Extremely wealthy people. They were both Republicans. They both had made their money in very successful business ventures. And so in some sense, you think they might have seen the kind of the law and the policy with similar eyes. But as we see today, with the difference, for example, between Donald Trump and Mitt Romney, for example, who, again, you could kind of say the same characteristics of those two gentlemen, and yet they seem clearly to disagree. Cullens and Melon had very sharp disagreements. Over the years, although he never wanted to be associated by name with them, Cullens's views tended to gravitate to the progressive wing of the Republican Party, which was still fairly important during that period. While this exchange was going on, and they are still submitting letters in the newspapers and kind of calling each other names and so forth, the second act starts. And the second act began in 1924 when, at the urging of Cullens, Congress agrees to launch an investigation of the Bureau of Internal Revenue. Now, this investigation was threatening to Melon in at least two respects. One is, obviously, as Treasury Secretary, he had administrative responsibility, and so anything that would be found in the investigation might come back to reflect badly on him. But in addition to that, Melon still had many important business interests which were affected by taxes, and there was always the possibility that the investigation would discover something untoward about how Melon's interests were being treated from a tax standpoint. The investigation was launched because of reports that Cullens and other members of Congress began getting of peculiar tax outcomes that the Bureau of Internal Revenue was producing. At the time, because in part of the first act, that is the public exchange of letters and so forth, there was suspicion on the part of some members of Congress that these peculiar tax outcomes was actually corruption. That is, these are simply corrupt tax favors being granted by the Treasury Department to some of Melon's companies and Melon's friends and associates and so forth. As it turns out, there actually was really relatively little evidence to justify an investigation. There were peculiar tax outcomes being produced, but for the most part, it was outcomes that resulted from the agency's unpreparedness of all of the changes to the tax laws that meant that the agency simply was, in fact, producing kind of inexplicable consequences. It was simply bureaucratically not prepared to handle all of the issues that had come before it. But the Senate, during this period of time, was, as one historian has indicated, was in a period of investigation hysteria. So this is the period where over half of the Senate was working on 16 special committees investigating some real and maybe some bogus Harding administration scandals involving the Interior Department, the Veterans Bureau, the Navy, the Justice Department, and finally now the Bureau of Internal Revenue as well. So while that investigation is now started and continuing, the third act begins, the third conflict. And the third conflict occurs in early 1925, when one day, while on the Senate floor, Cullens is called out of the floor by the Commissioner of Internal Revenue, who wants to meet with him off to the side in one of the little anterooms. And the commissioner presents Cullens with a piece of paper to sign. And the piece of paper is a request that Cullens waive the statute of limitations on a possible tax deficiency that Cullens would owe for his 1919 tax year. Now, I should tell you that the statute of limitations is simply a period of time that the Bureau has to assert a deficiency if somebody files a return and the Bureau determines that you are reporting too little of what you actually owe. It's a limited period of time to provide a degree of finality. So at some point, we all can feel, okay, well, it's been accepted. What we submit is accepted, and we don't have to worry about it anymore. What Cullens was presented was a piece of paper saying, we want you to extend the statute to allow us, the Bureau of Internal Revenue, to continue investigating and possibly assert a deficiency against you in the future. Cullens refused to sign the piece of paper. And as a result of that, the Bureau took what it had to take at the time. It was standard administrative practice, which is what it made was a so-called Jeopardy assessment against Cullens. And all that meant was the Bureau, not having completed its investigation, had to come up with a ballpark estimate of what would be the maximum amount of tax that Cullens might have to owe in 1919 if we had fully completed our work. And we will now assert that as what you, Mr. Cullens, owe. Obviously, it may turn out not to be true, but at least we get our foot in the door, right? Rather than not assert anything and be barred from ever asserting anything. So that's what the Bureau did. Now, at the time this occurred, there was a widespread perception on the part of people that this act on the part of the Bureau was simply retaliation against Cullens for his first public exchange of insults, if you will, and second, his convincing Congress to start this investigation and leading the investigation. Cullens, of course, fostered this impression. When it occurred, he refused to sign and immediately went back to the Senate floor, took control of the floor, and then made an impassioned speech explaining what had happened and what the Bureau was trying to do for him and what he had refused to do. Eventually, the disagreement did end up in a lawsuit because, again, the Bureau did make this Jeopardy assessment. The suit was very closely followed in the popular press. One newspaper called it, with a degree of hyperbole, the greatest tax suit in the history of the world, in part because obviously the background of the feud, the principles involved, the amount of tax involved, and importantly because the main factual issue involved the value of the Ford Motor Company stock that Cullens had sold in 1919. That was the key factual question. And since Ford at that time, the first Model T was sold in 1908. So by 1919, you still have a very young company. And to determine the value of the stock, you had to kind of go back and see, well, what exactly had happened. So this required a lot of factual development by the government and the Taxpayers Council to explain the basic facts of the start of what at the time was just a tremendously important and famous company. It also involved, of course, a lot of background information involving Henry Ford himself, who was a very controversial figure, as you all know. At the time, the three wealthiest people in the country were reportedly Henry Ford, Andrew Mellon, and John D. Rockefeller. And here was a case which at least collaterally involved two of those three. Well, at the end of the day, Cullens won the lawsuit. That is, the court found that he didn't owe more taxes, he actually owed less taxes as a result of 1919. That result, of course, simply reinforced the views of those who believed this was all a bogus charge to begin with. In any event, that's all background to give you a sense of where the Senate was coming from when finally it took up the House bill in 1926, and it used the information that had been developed from the outcome of the BIR investigation, which had found little evidence of fraud or corruption, but had found many dubious administrative practices. And the Senate was convinced that there needed to be some continuing oversight over the agency about how it was handling the various tax responsibilities. So the Senate proposed changes in 1926 to the House bill, which the House agreed to. One was to change the Joint Commission on Taxation to the Joint Committee on Taxation. Second was to make the membership House and Senate members, but no members of the public. Third was to make the committee a permanent committee and not simply a temporary commission expiring at the end of 1927. Fourth was to authorize the committee to hire staff. And the staff's duties would be principally to do two things: to provide simplification proposals, which was, of course, the House's main interest, and to provide oversight over the BIR, which was the Senate's main interest. One final responsibility, because the congressional investigation had been stymied to some extent by the tax confidentiality laws, the JCT and its staff were given access to tax return information, which remains the case today. Okay, well, let me turn at this point to just a couple of the specific points in the history that I examined where the contributions of the archival documents were particularly helpful. One issue involved a widely held view that in the course of their feud, Melon had violated Cullens' tax privacy rights. Now, this violation allegedly occurred during their public exchange of letters. Melon was in the process of urging changes to the tax law that Cullens was basically saying they aren't needed. And in one of the letters, Melon, which again was put in the newspapers, Melon wrote in the middle of the letter, quote, "Apparently you have paid no income tax," close quote. Okay? And then that led to the ending of Melon's letter, which is a very provocative one. Melon wrote at the end, quote, "Shouldn't a tax system be changed if it allows taxpayers with over $1 million in income to pay no tax in support of the government," close quote. Okay? So this is Melon putting this into the newspapers. Now, the reaction to that letter was to strongly condemn Melon and not Cullens. So Cullens is not criticized because he doesn't pay any tax. Rather, Melon is criticized because you violated tax privacy laws that exposed Cullens' tax information to the public. The law then, as now, essentially precluded the government from doing that, okay? These reactions were both the members of Congress at the time, the popular press at the time, and indeed many subsequent researchers, including one quite recent. So I don't know whether you're familiar with a biography of Calvin Coolidge that journalist Amity Slays put out just a few years ago. She described this incident, and she also essentially went on, along with this consensus view, that that Melon had violated Cullens' tax privacy rights in this incident. Now, in part, this reaction I found a little surprising. And the reason I found it surprising is that very early in my research, I discovered a letter that Cullens had put into the newspapers even prior to Melon's letter, that arguably was a letter that Melon is responding to. So remember that one of the policy disagreements that the two of them have is whether the tax exemption for interest on municipal bonds should be repealed. Melon saying it should be, Cullens saying it shouldn't be. So in Cullens' letter, he wrote and he said, you know, people buy municipal bonds not for tax reasons, but as safe investment choices. And then he added the key sentence. He said, quote, "This is my own experience, as I have largely invested my capital in municipal bonds," close quote, okay? And he puts that letter in the paper. Now, for some reason, that letter, although it's, you know, part of the public documents, was not widely reported, and subsequent researchers somehow have simply overlooked it, okay? Now, in a lot of ways, this is a very foolish statement that Cullens makes. For one thing, it tends to support Melon's basic argument that high taxes are distorting investment choices. After all, but for taxes, why would somebody largely or solely invest in municipal bonds? Melon himself, in response, said something along the lines of, gee, isn't it always wise to diversify your investments? And but for taxes, there are plenty of safe choices, including taxable corporate bonds you could be investing. So why would you put all of your capital in just this one particular kind of security? The statement also revealed a very personal reason why Cullens might oppose the removal of the tax exemption for interest on municipal bonds. If the tax exemption were repealed, the value of his bonds would probably fall. So he had just a personal reason why he would be opposed to that change. But the most important thing, of course, is it suggested at least the possibility that when Melon later talks about Cullens' taxes, he's not revealing something from the private tax records of Cullens, but rather reacting and reiterating in a rough way what Cullens has already revealed about himself. Okay? Now, when Melon wrote the letter, Cullens disputed the claim that he in fact had paid no taxes, and then he charged Melon with violating his tax privacy. So that kind of spurred on the kind of reaction. Well, in any event, I looked a little more closely at this dispute because it did intrigue me, and I did find some evidence, 2 helpful documents that related to this, although at the end of the day, I can't say I conclusively know one way or the other whether Melon violated the Cullens' tax privacy or not. One document I found, which was just a great find when I tripped over it, was a letter that Cullens' general secretary had written to Cullens, explaining some of the financial matters that Cullens had done in the early period of time. What the letter said was, in 1919, you sold your Ford stock to the Ford Motor Company for $30 million, which is about $500 million in today's money. And then, in the next 3 years, 1920, 21, and 22, he reported no income tax, no taxable income, okay? And then, in 1923, he paid some tax, but only $5,000, okay? And so all of this then fit very nicely to a statement that I had found on the Senate floor, which I had thought was kind of puzzling. During this period of time, again, there's a lot of fighting, and including fighting, debating on the Senate floor. And one senator who was very sympathetic to Melon basically raised a question of Cullens on the floor and just says, do you pay any tax at all, right? And Cullens answered, and this is in early 1924, he answered it, I have paid taxes in the last 4 years, which was kind of a puzzling statement when I read it just on the face. What does that mean? And now, of course, finding out the actual details, I understand exactly what it means, right? Now, what does this letter do? Well, in part, at least to me, it is a damning letter to Cullens, or against Cullens, because it tends to make him look a little bit like a hypocrite. He is arguing as a policy matter, taxes don't influence people's choices and what they do and so forth. And yet, look at his behavior, right? What in fact did he do? And in fact, he was able to avoid paying taxes completely, even though he had this huge amount of capital that he had just gotten from his sale of Ford stock. On the other hand, it also could be damning to Melon. And the reason is, if you look closely at their statements, the 2 statements that were published are a little bit different, right? Cullens says, I have largely invested my capital in tax-exempt bonds. Melon's statement is, apparently you paid no income tax, right? Now, the 2 statements are not exactly alike. Melon's statement is a lot more pointed and specific. Now, it's possible that Melon is just kind of reiterating what Cullens says, but making it in a little more of an embarrassing and pointed way. You could imagine it in a public debate, you might want to kind of, exaggerate a little bit that way. On the other hand, you could also imagine that Melon actually did look at the tax returns and found this astonishing fact that he paid no taxes, right? Which then Melon really has a reason to kind of get out somehow, because it's an unusually embarrassing possible point to make. And so he then makes the statement he does. So the bottom line is, I don't know, right? It could have been either one. The other document that I found was a private letter that Melon then sent to Cullens, clarifying that, gee, I would not have raised your tax situation but for the fact that you mentioned it in your letter, okay? Now, you can look at that and say, well, that clears it up, right? Melon really didn't do anything untoward. On the other hand, you also have to understand that this could be a completely self-serving letter that he's making. We, again, don't really know what he did, but it is a way to kind of cover up what he might have done by making that representation. So at the end of the day, we don't really know. Let me just mention one other incident. How are we doing on time? Okay, I'm getting close. Maybe I should then skip over this second there. I will just mention that the one other topic that really intrigued me was the notion of retaliation. That is, was that lawsuit retaliation against Melon? And I'll just have to leave you to read about this in my work, because it is quite interesting. Let me then conclude then by just mentioning a little bit of the ongoing work and possible current implications. One thing about the staff you should know is roughly in fact I was mentioning this to Rod before we started, roughly during the first 50 years of its existence, it had kind of a monopoly in Congress in providing professional assistance in the tax area to the various members. And as a result of that, virtually any of the major issues that were resolved and enacted during that period of time, in one way or the other, went through the staff. And so part of my research is to kind of highlight just a couple of those areas and try to learn something. Many of these aspects are still part of the law today. In that sense, obviously some of the origins could be very important and helpful to us today. In addition to that, I want to look at the legislative process a little bit. So what happened after that first 50 years? Well, obviously things changed. And how did things change? Well, in some way, you could think of the Joint Committee staff as having been a victim of its own success. So during the early period when it had this monopoly, it was able to make a positive enough impression on Congress that by 1946, or about 20 years after the Joint Committee was created, Congress decided, hey, this idea of having professionals helping the committees, this is really a pretty good idea. There are a hell of a lot of other committees and they need help too, and the law is equally as complicated and so forth. And so why don't we authorize committee staff, professionals, to help with those other committees as well? And they did that in the 1946 Reorganization Act. In the 46 Act, they deviated from the JCT model by not having joint committee staff serving both House and Senate at the same time, but rather having separate House and Senate staff. But they agreed with the Joint Committee model in designating nonpartisan staff. So they authorized the House and Senate committees to hire a certain number of professionals on a nonpartisan basis. Now, what happened? As it turns out, within the next 5 to 10 years, various studies were made that showed that, in fact, about half of the committees did not hire on a nonpartisan basis. Some number of the committees, the hiring was done exclusively by the chairman, and some of the chairmen exclusively hired staff to help the majority members of the committee. And as a result, some of the committees, the minority, was just cut out completely. Over time, as you could imagine, there was unhappiness with this, and eventually there was another reorganization in 1970, and the 1970 Act created what is the form that we know today, which is the formal notion of a bipartisan staff, some members, about 2/3 designated for the majority members, about 1/3 for the minority members. Okay, that leaves us with the situation that we have today. And shortly after that, you suddenly see in the tax area, as well as a number of others, but at least in the tax area that the Joint Committee works in, a lot of competition. So now you have members both on the House and the Senate, majority and minority, professional staff, all of them, as well as the Joint Committee and so forth. Now, one of the ironies is the Joint Committee, when it got started, had some conflicts with the Treasury Department, because before the Joint Committee was created, the only professionals who were advising Congress were in the executive branch. Treasury would come over, they would have the experts and the staff and the data and make their presentations and so forth. And it was partly in response to that that Congress said, we don't want to just rubber stamp. We need people who are actually going to make an independent analysis. So the Joint Committee was started. During the initial years, you can imagine there's some conflict, right? And during that transitional period, you kind of see one of the advantages that the Joint Committee staff over the Treasury, they were not as experienced, they were smaller, right? But one thing that they had that the Treasury didn't have is they had access. They were right here, right? They were right down the hall from Chairman so-and-so and so forth. And so Chairman so-and-so got used to talking to, Joint Committee Chief of Staff as opposed to calling over to the Treasury Department and so forth. Now, mid-70s began, and suddenly you see this proliferation of staffs. And you see the worm turn. So just as the Joint Committee had the advantage of access of the Treasury, you see now the committee staffs having the advantage over the Joint Committee in terms of access. Because now the members are working with their own staff, who they really do see on a day-to-day basis, where the Joint Committee is just kind of a resource that is there to be called upon, but not kind of directly working with the members themselves. And so you do see this kind of change, and that has resulted in an evolution of the impact of the Joint Committee in the tax legislative process. One of the questions, obviously, that I want to try to explore in some way is first, why wasn't the Joint Committee model replicated more closely? And second, is there a continuing role in the legislative process for a nonpartisan and joint staff? The Joint Committee has really been the only one. It was successful for the period of time that it had the monopoly. Now it's much more of a kind of an iffy question, how useful it is and how effective it can be. And so one of the questions I want to explore is to get that issue out. Thank you.
We're pressing up against the limit, but we'll have time for a couple of quick questions. Yes, Carl Henry.
Thank you. Carl Henry Geschwind. I was just wondering whether you could give some advice then on archival sources. In the 1940s, 50s, 60s, when the Joint Committee was advising Congress, as well as the Treasury Department, for the Treasury Department, you've got the Office of Tax Analysis, Office of Tax Policy files over in College Park, which have a lot of the internal staff memos where you can actually see policy being developed and then being given on to the Secretary of Treasury to say yes or no to. When I look at the Joint Committee of Taxation files here, it seems like Cullens Stamps files has his external correspondence, but there are no staff memos there. So how would you be able to actually trace how policy is being developed within the Joint Committee of Taxation staff?
So that's a great question, and it is a real problem. The committee staffs, I mean, I'm gradually kind of seeing, both because I've been there, so I kind of see how the staff works, and then I'm kind of imagining how things happen. One of the difficulties of collecting committee staff papers is it can be kind of a mishmash. So you have a range of people. I know through historical documents who the people are, but I don't always know, and in fact many times I don't know, who the people are who are preparing the documents, because a number of the documents are undated, unnamed, and so forth. I don't know if it's a draft or a real thing. And then, of course, one thing you're not aware of at all is the information that gets conveyed that isn't documented at all. So you have a whole lot of kind of holes that you have to kind of try to piece through. I've been to a number of the files at the Treasury Department in College Park. And for the most part now, admittedly, I've been mostly looking at the Office of Secretary and the key deputy offices. Those files are incredibly well organized compared to the Joint Committee. And again, I can kind of picture it. The Treasury Secretary obviously had an assistant or two whose responsibility was to keep track of the paper and put it in the right file and get it over to the archives when it was time to do that. Likewise, the assistant secretaries and so forth. Joint Committee doesn't operate that way. It's a very, kind of thin organization, a number of professionals, each doing his or her little thing. At the end of the day, the chief says, "Oh, time to send things over to the archives. Give me the boxes," and shove it all in there. And then, of course, I can only imagine how hard it is for the archivist to look at this, because obviously this is not only material that hasn't been well organized, but it's also involving subject matter that's just incredibly impossible for someone without the background to figure out. So yeah, that's been a real challenge. I look at it kind of on the bright side, which is there are not a lot of people who are looking at the historical documents that have my background. And so I kind of figure, you know, if I can figure something out, I can really make a contribution here that maybe nobody else is going to be able to figure out. And you know, one of the things I didn't mention, but I wanted to mention, is that on some of the matters you can see, you know, a historian, a political scientist, a journalist, and so forth who's writing, they obviously can do tremendously good work. One thing they don't always understand is the underlying tax issue very well. And that sometimes causes some misunderstanding about something. And so, you know, I kind of feel, well, all right, there's an opportunity there, but how successful I can be, I don't know. So it's a great question.
One more quick question.
I'm just curious, because the one constitutional authority that the House has that the Senate doesn't have is to start revenue bills, and they're rather jealous of that provision. Does that affect your committee, the fact that the one House is going to automatically begin the process, and how do you divide up that that practice?
Well, it actually works to the advantage of the committee in that there is kind of an order to the process. You know, if sometimes both committees are acting simultaneously for various reasons, that really stretches the committee staff very thin because it's got to be in two places at once. But most times there's a sequential steps. The House does go first. The House will hold hearings, the House will develop proposals, the House will produce a bill. All of the committee, or most of the committee's staff's resources are devoted to helping the House. Then at some point, the House produces a bill, it gets passed by the House, it gets shipped over to the Senate, and then the committee turns to that. It really works tremendously well in when the process follows that procedure. When conference arises, I mean, I've always felt the joint committee model is just so great for conference, because when conference arises, you have a set of staff who've worked closely with both sides, and they understand, you know, what the House was doing with its bill. They understand what the Senate was doing with its bill. They can sit there, and then testify to the conference committee and explain to them, you know, look, this is what was going on, and so forth, and maybe come up with some proposed compromises and all of that. It's really a tremendous model when it works like that. When you have separate staffs, each staff only knows half of the picture, right? Now, unfortunately, in today's world, and this is really the last 10 or 15 or 20 years, the legislative process is so totally broken down. I mean, you know, how many times do they have conferences anymore? Public conferences. You know, they still have the private person-to-person conferences, which I've sat in on and so forth. But the public conferences where the conference committee meets and discusses and argues and so forth, that almost never happens anymore. So in some sense, you know, that's part of the issue too.
Let's thank George again for his wonderful presentation, for sharing his really deep knowledge and insights on this policy and institutional context. Thank you so much, George.
Thank you.